In a significant development today, after holding a late evening hearing, the Supreme Court ordered status quo with respect to the use of the land of the Idgah Maidan in Bengaluru's Chamarajpet for Ganesh Chaturthi celebrations tomorrow, thus in effect putting in abeyance the Karnataka High Court's verdict that had earlier permitted the Ganesh Chaturthi celebrations to be conducted there. A bench comprising Justices Indira Banerjee, A.S. Oka and MM Sundresh passed this order after taking into consideration that for 200 years no such celebration of Hindu festivals had taken place on the land in question. The bench orally remarked during the hearing, and I quote here, "For 200 years it was not done, you also admit, so why not status quo? The 200 years whatever was not held, let it be." Accordingly, the bench directed the Hindu community to conduct the puja somewhere else. The bench also remanded the matter back to the single judge of the High Court to decide the matter on merits. The matter was heard today by the three-judge bench following a difference of opinion between the roster bench comprising Justices Gupta and Sudhashnu Dhulia. The two-judge bench, which initially heard the matter, referred the case to a three-judge bench without passing any order of status quo. The three-judge bench was thereafter constituted after Senior Advocate Dushyant Dave, appearing for the Waqf Board, made an urgent mentioning before the Chief Justice of India, U. Lalit, stating that if the matter was not heard today, then the status quo of 200 years will be disturbed. The Supreme Court was hearing two appeals filed by the Central Muslim Association of Karnataka and the Karnataka State Board of Oka challenging a Karnataka High Court verdict. The appellants had challenged the grant of permission by the state government to conduct Ganesh Chaturthi celebrations in what they claimed to be a Waqf property. The original petition in this case was filed by the Karnataka State Board of Oka challenging an order of the Bruhat Bengaluru Mahanagara Palike, that is the BPMP, refusing to record the land in question in the board's name by contending that the land belonged to the state's revenue department instead. To provide a bit of context for all of you, the appeals in the Supreme Court were filed challenging an order of a division bench of the Karnataka High Court allowing the state government to consider applications seeking use of the land of the Idgah Maidan in Bengaluru for religious and cultural activities. A division bench of Acting Chief Justice Alok Aradhe and Justice Savanur Vishwajit Shetty had passed the interim order while considering the state's appeal against an interim order passed by a single judge. The single judge bench of Justice Hemant Chandagodar had earlier allowed the use of the Idgah Maidan only for Independence Day and Republic Day celebrations as a public playground, and for the use of the Muslim community only to offer prayers on the days of Ramzan and Bakrid festivals as an interim measure. However, this order was modified later by the division bench by permitting the state government to consider applications for all religious and cultural activities for a limited period of time from August 31st onwards, while the dispute to the title of the land was pending before the court. During the hearing today before the Supreme Court, Senior Advocate Dushyant Dave, appearing for the Waqf Board, submitted that under Section 3 of the Places of Worship Act, there is an absolute bar against conversion of use of religious land for any other religion. It was further claimed that the Muslim community have been in uninterrupted possession of the land in question since 1871, which was used as a place of worship and a graveyard. It was also stated that Articles 25 and 26 of the Constitution expressly protects the rights of religious minorities to possess their properties. On the other hand, Senior Advocate Mukul Rohatgi, appearing for the BBMP, stated that the state government is the owner of the land in question and that it is not a Waqf property. During the course of the hearing today, Justice Oka asked Senior Advocate Mukul Rohatgi whether in the past the state or the BBMP has allowed Ganesh Chaturthi festival to be conducted on the land in question. Rohatgi, however, responded in the negative, adding that even if it was not used in the past, it cannot be an argument to say that it cannot be used now. Pursuant to the submissions of the respective parties, the bench ordered status quo in the matter and remanded the matter back to the High Court to decide the case on merits. Thank you. This is Aratrika Bhaumik for LiveLaw. For more such updates, please do not forget to like and subscribe to our YouTube channel.